This is TWiT.
This episode of Tech Break is brought to you by ACI Learning. Certificates open doors to entry-level IT positions and promotions for those already in the field. CompTIA courses with IT Pro from ACI Learning make it easy to go from daydreaming about that career in IT to launching it. Visit go.acilearning.com/twit to learn how you can elevate your skills. So, Cathy, many think that yesterday was one of the most momentous days in the history of the Internet. Of course, the Supreme Court had oral arguments on Gonzalez versus Google. This was the case. Sad story. The Gonzalez family filed against Google saying that ISIS recruitment videos on YouTube, well, they don't even say it was the cause of their daughter's death in a 2015 terrorist mass killing in Paris, but they say it's bad anyway. And so it seemed to me it's a bad case on the face of it because there's no connection between those videos and their daughter's death, and I'm very sorry for their daughter's death. But they went after Google anyway. There's another case that was heard today, similar but not the same. Yesterday's case really was about Section 230. Today's case included Twitter and I think Facebook as well as Google. But wasn't.
I'm not sure if they were official petitioners, but I may be wrong. I don't remember the caption, but it's definitely Twitter that was pulling the weight, I believe.
You went to the oral arguments yesterday. Did you not feel that today's were as important, or were you just exhausted?
It's the latter. It's an oddly arduous experience physically. It's there was a lot of anxiety heading into it, and me and all my colleagues were coping with great amounts of stress about existential stress of what was going to happen, and everything we work for and everything we care about was really hanging in the balance. So going into that, and then you have to wake up really, really early to get online because you don't know how many people will be there and want to get in. You don't know how many people they will let in. I got to be on the special line for members of the Supreme Court bar. But even so, it was still unknown of how, like the last one I went to, the Andy Warhol case, they didn't let everybody in who was a Supreme Court bar member. And I didn't want to be like the last person who got left out. So I had to go early, standing around. Then you get brought into a different spot and you stand around some more, and there's more standing and more sitting. So looking at it for this morning was sort of, maybe I'll give it a miss and I'll take care of some other stuff and just listen in. But on the other hand, the trade-off is it is definitely different to be in that room and see the justices as human beings and see their body language and see the way that they sort of look at each other and react to each other physically. It is definitely, there's something that is lost when you just put it into the sound that goes through the radio or the live stream.
So you just don't see them flipping the bird at each other as we hear the court is doing these days.
I don't think actually that is something that has ever caught my eye on any of them that I've attended, but
they actually seemed
they were
quite collegial.
I thought. Rolled eyes.
They are very collegial. I mean, there's a certain cognitive dissonance, and there's going to be one that I'll end up talking about a little bit more, which is to go a little spoilery. One of my favorite justices as either of these hearings unfolded is Justice Kavanaugh.
Brett Kavanaugh actually seemed to know something about the internet.
In a very distinct way. He understood really important things where if I, got to write a memo of bullet points of, dear justices, this is what you need to know, which is essentially what I did in writing an amicus brief.
You wrote a brief for the first case for Gonzalez, yeah.
I wrote one for the first case for Gonzalez, but I would have put a list of this is how you look at it, and his questions were articulating and understanding. That was
maybe
everything I thought.
I was also impressed. I also appreciated Justice Kagan saying these are not the 9 greatest experts on the internet. She was at least humble. So, but before we get into the details of the argument, so there were 2 cases. The second was Twitter versus Tamna. So Twitter was the plaintiff, or no, I don't know. Twitter was the defendant in this one.
They were both the defendants, but it was reversed in terms of the petition for the certiorari.
Okay, so Twitter asked
case,
for this one to go to the Supreme Court. Is that right?
Twitter asked for this one, and it was a contingent petition that basically said, if you're going to take the other one, take this one too. And then, but that's why Twitter was sort of the lead in this one, where it's Twitter versus Tamna. But for the other one, it's Gonzalez versus Google, because in that one, it was Gonzalez that said, "Dear court,
appealed.
Please look at it."
Okay.
So, yeah.
And the Twitter case, apparently, I've heard, is not quite as directly an assault on Section 230. Tamna is accusing Twitter of promoting Islamic terrorism by allowing tweets, basically, and retweets on its site. But the first case, yesterday's case, I guess the first question I would ask is, why did the court agree to review either of these cases?
Yeah,
they're not great cases.
I think the court is currently asking itself that very question. And I say that somewhat flippantly, but I think what we think is that there had been an appetite to take a Section 230 case, because we were seeing these, and I'm forgetting, I think they were concurrences, not dissents, or they were dissents against denial of certiorari. So we had the Malwarebytes case, and then there was another case later where Justice Thomas wrote at least one of them. I think Alito may have written another one, where these were things of like, we have never considered Section 230, and boy, what a big deal. We better make sure that this big monumental law is really doing things, because there were complaints by people that they politically related to, who had been complaining about, well, Section 230 is the bane of all the existence, and this is why all these people with these political views are getting censored, et cetera, et cetera. This isn't actually the case, but this is a view that is held by people that they politically agree with. So they were expressing an appetite of, we should take a case. And then all of a sudden this case comes, and it looks kind of provocative. It's got terrible optics. It's like big bad Google. Out of nowhere, they took it. I mean, I think it really blindsided the community of lawyers that I'm operating within. We just didn't think this was a case that was going to go anywhere.
Why was that? Is it because it's a weak case?
It was a weak case. I think it was weak facially, and it was just one in the many cases.
Right.
There's these plaintiffs' lawyers who keep trying to. Terrible things happened. A terrorist has caused collateral damage to innocent people, and, well, I guess by their view, it's not collateral, but then there's all these people who are like, well, somebody must be blamed. These terrorists were using the internet, so let's blame the internet. So there's certain lawyers who kept bringing case after case and then losing for a variety of reasons. They kept losing. Some, I think, lost on 230 grounds. Some were losing on ATA grounds. Some were losing because just the complaints, like, you have to have causation of the harm and the consequence.
That's
have some sort of link. But lawsuits are expensive. So, one of the points of 230 is that, like, the lawsuit goes away very quickly, where it can't get to a point where you've really spent any real money to find out that you had no liability in the first place. But somehow this case got escape velocity, partly because the Ninth Circuit, I think, is getting very grumpy about 230 itself and is starting to kind of try to snip at it a little bit and cut its corners in ways that I think are not a good idea. In this case, I think they looked and said, well, precedent binds us to get rid of the Gonzalez complaint because of Section 230, but they had like all this language about like, but we don't like that. That doesn't seem right.
Even Justice Kavanaugh said yesterday, this is really a matter for Congress, not us.
Well, so to my long-winded answer to your question is, they took the case, they ended up taking both cases, but then I think a couple things happened. One, the cases themselves were weak. I think they noticed once they started reading them more closely. I think once the briefing came in, they noticed it more closely, because the Gonzalez case has a problem where certiorari is granted, which is the Supreme Court review, to say, we're going to look at this particular question of law. And when they grant the case, they grant it with the question of what they're going to look at when they do this review. And when the petitioners filed their brief, they changed the question, and you're not supposed to do that. I mean, that's enough grounds to kick the case unto itself. But then the other thing that happened is a gazillion, and I'm rounding slightly, a gazillion amicus briefs came in.
Including yours.
Sides, including mine,
yeah.
But particularly on the side of Google, where the bulk of people talking about the parade of horrors that was going to happen if Section 230 got cut in some way, I think really impressed the court, where they started to realize there was a there, and they did seem with one possible exception, they seemed generally much better educated on the issues than I think we had expected. And I think that education may have shaped their views where they realized that more was at stake. And especially with a weak case that was weekly pled and weekly briefed and weekly argued, I think now they're like, wait, big things are at stake and we're going to topple a lot. We see what's at risk over this. So I think they're having second thoughts about having granted for Gonzalez and also peripherally with
Cathy,
the Tana case.
If they get together in their club room and say, oh, we shouldn't have taken this, there's really no issues here, there's really nothing, can they just issue like a one-pager that says never mind? Or do they now have to deal with much of what was argued?
I think they have choices. I don't know entirely technically what all the choices are, but on the other hand, they also have been making an awful lot as they go on these days. So I think it'll be whatever they want to be. There's something that is referred to as a dig. I've seen people refer to it, and I don't know the full acronym, but it's basically improvidently granted is the problem, where they're just going to like set it aside.
We blew it.
That is a thing. Yeah, so they could do that. I mean, I think they have options. I think they could do that just blankly. I don't know what that looks like, but maybe it is a one-line order. They could just find in favor. They could find in favor as a per curiam and not write any language, I suppose. They could write language. I don't know if it's even worth guessing or even looking up past Supreme Court process, because they're going to do what they're going to do. But I think they do have options, and the idea that they could say oops and not render a decision in the case, I think is something that they could do. And have
how
done
did
before.
Google do in the arguments?
How did they do in the arguments?
Yeah.
There were a couple things I think they conceded that the community will not like. I point people to Eric Altman's blog and his objections to the Henderson case, because Google said that they kind of liked the Henderson test, and even the justices were a little bit like, I think one of them actually said, "Are you sure?" So I'm not entirely sure that was the best way to zig and zag. I think the Google lawyer also had trouble connecting with Justice Jackson. Justice Jackson, I think, does not quite see the situation the way it needs to be seen yet.
She said several times
Google's
how confused she was by the whole thing.
Well, and I'm concerned also, she said, Section 230 is a narrow statute. And I'm sort of like, well, I really wish you read my amicus brief. I have a whole section titled how it's a broad statute on purpose. So please read my brief. I think it'll educate you.
Let me read Section 230 just so that it's very quick. It says, as you've pointed out a bunch of times, Jeff, it's 26 words that change the internet.
The key section of it, yes.
No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So the point of this, and Ron Wyden wrote it kind of as an antidote to some of the features of the Communications Decency Act, but the point of it was twofold. One, you're not responsible, whether you're Twitter, Google, or Leo Laporte running an IRC, for something somebody puts in that IRC. They're responsible, not you. You're not the publisher. And two, if I decide to moderate any of these, or Google or Facebook or Twitter does, I am not liable for taking it down. And in fact, I think Ms. Blatt, the attorney for Google, said, if you overturn this, you've got two choices. Either the internet's going to become this anodyne happy place where nobody says anything controversial, or it's a hellscape because nobody can moderate and there's nothing in between. So this was quite a, I think, brilliant, prudent, and I think very broad part of the code that really did make the internet a safer place for people like me. And this is always the thing that irritated me, is that everybody treated it like, well, we're going after Google or Twitter or Facebook. Those guys actually could weather the loss of 230 much better than I could. But I have a forums, I have chat, I have a Discord, I have comments, all of which I would suddenly be liable for, and it would make me...
Go
ahead.
relevant to the brief, you have a Mastodon server.
Right.
And so one of the key things about my amicus brief is one of the signatories is an admin of a Mastodon server. Because one of the things that's happened as this whole case was unfolding is cert was granted, then Musk took over Twitter, and all of a sudden you had the exodus. So Mastodon was becoming more and more prominent, used by more and more people, and the importance of having this alternative was getting more and more important over time. And it seemed to me that we should have that voice brought to bear to explain to the court that it isn't about Google. It is about individual people who are trying, either as a small business or just for the benevolence of trying to serve their community, offering a vehicle so that other people can speak to each other online.
Yeah,
and that matters.
I make no money on Mastodon, Discourse, our forums, on our IRC. Those are all outbound. I pay for all those without any monetization. And as a result, if I were suddenly liable, so with the nice thing about 230, if somebody comes after me, I think this is right, Cathy. I don't even have to defend it. The judge is going to say, no, they're protected by 230. That's dismissed, right? There's no.
I mean, you have to do a little bit of lawyering to that. It's not quite as automatic. You have to plead it, but it should basically be that the judge says, there's nothing to go forward here. This is not a question. This is an easy thing.
It's pretty automatic. And I could bear that burden, but if I have to suddenly have to defend everything, and believe me, there are plenty of people on the internet who would file frivolous lawsuits in an attempt to bring us down. If I had to defend every one of those, every decision whether to moderate or not, I'd be out of business. So I think we would preemptively shut everything down. It would chill discourse on the internet.
It would chill discourse. It also chills your expressive discourse. Yes. You are very similar to Mike Masnick, who has a business, and his business is to contribute to discourse, to get his own expression out there, and to make sure that other expression that he agrees with and support with can get out there.
But he's a publisher, right? So he's liable as a publisher. 230 doesn't protect his opinion.
No, not his directly. However, the point being is that some of these ancillary things where you're providing the forum for other people to speak is in line with furthering your own expressive interest too. That you, as a person whose business is expressing yourself, needs the ability to have these ancillary avenues for both to use your own speech to make sure that your shows can be tweeted and shared around, but also that you can nurture the community of your audience, because you will make your business succeed by connecting with the audience, and having the ability to host these forums is also helping you build your audience as an expressive entity, which the First Amendment protects and encourages, and democracy needs people like you to tell people things and keep the discourse going. So there's First Amendment stuff everywhere you look with it, and Section 230 is all about making that meaningful and redeeming and vindicating those values. And it's such a shame that people keep missing it and interpreting it as something exactly opposite to that.
I was going to ask you if there was some type of middle ground with Section 230 versus the people that are like, we need to just
I think Mike Masnick put it best. If you split the baby still dies.
Actually, did he say? I'm looking at my brief right now. I think
was that in your brief?
I had some line like that in the.
He stole it in his post today.
Yeah. Mike is stealing my best material. I'll have to take this up with him.
But that's a great question, because in fact I even said, well, because they had modified the complaint to say, well, it's the algorithm that's the problem. And I was saying, oh, maybe they could just say no algorithmic recommendations in 230. We protected. Of course, Jeff spanked me hard on that. I'm still feeling it a little bit.
You open-minded, wise man that you are, changed your mind about that.
Oh, completely.
I'm proud of you, Leo.
So Ant, is that what you're thinking? Is like is it possible to kind of slice this a little bit so that you have some more protection, but that 230 is still intact?
Yeah, but at the same time, our leaders are also saying, hey, these big tech companies can't censor us either. So where's the line that we're going to draw?
Not there, because I mean, one of the things is that the way the ecosystem works, and let's look at Twitter and Mastodon as an example of that. Mm-hmm. So Musk owns Twitter, and previously Musk didn't own Twitter. So Twitter was making decisions about who to allow to use Twitter and who not to. And these decisions, especially the ones that said go away, were not liked by the people who had to go away. I can understand the the hurt feelings from that. So I don't want to poo-poo that, but Twitter could make those decisions. Now Twitter's owned by somebody else, and he can make different decisions based on who he wants to be associated with, just as Leo can make decisions with his Mastodon instance of who does he want to be associated with.
And I do every day when I approve or disapprove new users.
And individual people can do this too. So for instance, if you've got a Facebook page and you make a Facebook post that people can comment on, and somebody like you've posted a picture of your kid. If somebody comes over and says your kid's ugly, you certainly want to be able to get rid of that comment and potentially block that user from coming back and commenting because that's not comfortable to you. And you can sort of understand the editorial freedom you have to be able to make that decision. Just similarly, the opposite is true. If somebody comes and praises your kid, you wouldn't want any law to be able to compel you to have to take that comment down because that's your favorite thing.
Oh, this is interesting. Just a side note. The ability to block somebody, which is integral to both Mastodon and Twitter, would that also be, is that protected by 230? Would that also be at risk? My personal ability to block somebody on that site?
If 230 should operate. If 230 starts to get clipped, then it's unclear exactly how much devastation could follow, because in theory, it could be all of it. There's a lot of thought about, we'll just make it a narrow snip here and there. And no, that's why the baby Mike and I are using the baby analogy, because the whole point of the Solomon story is that there are certain things where the compromise is impossible.
Neither party was willing to split the baby. That was brilliant. Solomon's decision was brilliant, right?
And, so Leo, and the whole thing is that you can't have that split, because I think the way I phrased it in the brief was it would be fatal to the purpose of what you're trying to do. Right. The problem with, if you're a platform who's going to potentially be sued for all of the gazillions of bits of user provided information you have, even one of those lawsuits, even if it's a non-meritorious lawsuit where you would win, can wipe you out. And certainly if you've got more than one, then you don't stand a chance. So you want to avoid the lawsuit because you can't afford the lawyers. The problem with clipping away at Section 230 is that if all of a sudden you're having to spend your money deciding whether Section 230 applies to you, then it doesn't really matter whether it applies or not, because you're still going to drown in the litigation. Because it was never about whether the litigation was valid in the first place. The problem was the litigation is going to bleed you dry, and we need to make sure you don't get bled dry, because if you are, you're not going to be able to be in the business of helping people speak to each other online.
So Eric Goldman, writing about certiorari in his technology and marketing law blog that you referred to, said, I love this. I remain unclear why the court granted cert in this case. The plaintiff's arguments were so weak, the justices really didn't know what to do with them. A tip-off came with Justice Thomas's very first question, asking if the ISIS recommendations were the product of a, quote, neutral algorithm. This is a Google favorable question. Justice Thomas had begged plaintiffs to bring him 230 cases, and now that he has one, apparently he's like, WTF. I imagine the other justices who voted for cert felt similar qualms. I was really heartened by people like Gorsuch, Kavanaugh, and Thomas, and Alito even, people I thought, these are the guys who really want to kill 230, really asking pretty astute questions in mostly in Google's favor, I think. Now, Cathy, before we go too much farther, I've said this before. I know others have said this. You can't judge too much based on the oral arguments, right?
Absolutely true. However, I think the same thing that Eric was commenting on is probably something that is probably true. We were expecting a very hostile audience that was holding on to a lot of the myths that are so pervasive in public discourse about 230, what it does and why, or why it's important or not. We didn't get that. We ended up getting a bench that was surprisingly informed and seemed to get it and seemed to understand what was at stake. And we're kind of grappling with that because we're not used. If you practice in this area, you're not used to having good days. And it actually seemed like something like, wait, must be too good to be true. So how could it be true? I think, though, the problem is we might still get a little complacent because I think Google will win. I don't really think that the number of votes is in question. I mean, they might just get rid of the whole case, but if they decide it, I think it's not an issue where the petitioners are going to win. I didn't sense any appetite by the justices. They didn't seem impressed by that Gonzalez argument at all. but it's not enough. The problem is if they kind of start to speculate about potential limits to Section 230, even though that language is probably going to be dicta and so not particularly binding, it's just going to make an absolute mess of things and start to essentially become binding precedent as other courts interpret it. And it's going to be a roadmap for all the future litigation to challenge Section 230.
Yeah,
so
let's not forget that
until we get the decision.
In the Henderson test, the judge quoted Thomas's dissent 3 times.
Right.
So
I think that might be why the justices were like, are you sure you like this? Because it wasn't like something you absolutely hate at the root of it.
It was kind of shocking. So sometimes the justices will play devil's advocate. They will attempt to, they'll sound like they're in favor of an argument because they're attempting to find the holes in it, et cetera, et cetera, et cetera. Which is why you don't know what's going to happen. This will be what they'll announce if they do continue with the case roughly in June, right?
It's hard to say. I mean, last time I think I was here, I was talking about the Warhol case. So that was October, and there's no decision there. So they're starting to render decisions, but on a schedule that is
months
only
out.
Known to them.
Right.
So yeah.
But it's at least months out.
Yeah.
So we'll have you
most
back
likely,
then.
but
either to celebrate, we'll either have a cake or we'll all be dressed in black.